Assalamualaikum, my name is Muhammad Azamuddin bin Khalid. We are from Group 1. We'll present the case study about Sharia Maxims and their implications on modern transaction. There are three Islamic legal maxims involved in this case study. The first Islamic legal maxim is Al-Umuru bi-Maqasid biha. Actions are judged by the intention behind them. It means that legal consequences of any action are determined by the intention and purpose underlying it, not just the words used outwardly. A contract should be understood in relation to its intention and content, not by the words and phrases used. In modern Islamic banking, this is to prevent practice such as labeling interest-based financing as buyback, additional or value-added, while maintaining a fixed return because the bank must actually avoid riba and not simply rename the transaction. For example, musyarakah or mudarabah contracts, which ensure that the bank's profit remains violate it by shifting of risk to the partners, making it impermissible. This maxim requires that the practical effect and actual purpose of a transaction must be in accordance with Sharia principles, regardless of the terminology used by the parties. The second Islamic legal maxim involved in this case study is al-yakinu la yazulu bi-shak, certainty not overcome by doubt. This maxim established the importance of certainty as the basis of legal judgment. When a fact or legal situation is established with certainty, yakin, it cannot be annulled or withdrawn merely because of subsequent doubt or shak. The party asserting a change from the known or initial state of circumstances carries the burden of proof. According to Al-Aslu Bara'atu Zima, a partner in a partnership who reports a profit cannot be assumed to have made more without evidence or to prove non-liability as incompetence. In order to avoid unfounded claims of carelessness or increased revenue in the transaction, this is to guarantee equity in the distribution of profits. This offers stability and confidence in a legal and financial setting, for instance, by maintaining the current ownership of debt status quo, unless clear-cut proof indicates otherwise. It safeguards rights already in place and avoids invalid allegations based only on suspicion. The third Islamic legal maxim involved in this case study is ad-dararu yuzal. Harm must be eliminated. According to the fundamental principle, it means that any kind of harm or injury must be eliminated. This maxim is a statement of the Maqasid Sharia, the goals of Islamic law, one of which is to improve people's well-being by protecting their wealth, al-mal, and other critical interests. As a result, any activity or transaction that is harmful or against the public interest ought to be outlawed or removed. In order to prevent mutual loss, merchants may cancel contracts for perishable items and purchasers may return damaged goods, khiyar al-aib, but greater injury is favored over lesser harm. This is the reason why transactions with significant uncertainty, horror, or speculation that could result in widespread loss or exploitation are prohibited in the Islamic financial industry.
Hi and Assalamualaikum. My name is Naatira binti Abdullah. So here I will present in my part for question number 2 in case study, which is implication of the legal maxims. Matters are determined by intentions in financial transaction. The first one, I will give you meaning of the legal maxim. The maxim al-umur bi-maqasid means that the validity of the actions depends on the intention behind it. In Islamic law, this principle applies not only to worship but also to commercial and financial dealings in muamalat. In financial, this means a transaction is evaluated based on its real purpose and outcome, not merely its documentation. Second, with substance over form in financial contracts. Islamic law prioritizes economic substance rather than legal form. This is supported by the sub-maxim in contract the judged by their objective and meanings, not by words and structure. A contract labeled as Islamic can be Sharia, non-compliance if its substance contradicts Islamic principles. Next, preventing from base or contract compliance. Some Islamic financial products imitate conventional loans while using Islamic terminology. If the intention is to secure a fixed, risk-free return, the transaction violates the maxim. The maxim prevents rebranding riba-based products under Islamic names. For example, murabahah without real assets. From ownership to intention is leading, not trading. Next, we discuss riba. In riba is prohibited not only in the name but also in effect and attention, even if no interest and explicitly state Guaranteed monetary gain indicates riba-like intention. The maxim ensures that hidden interest elements are identified and rejected. Next, reinsuring entities risk sharing. In risk sharing contract, which is musyarakah mudharabah, are to Islamic finance. Genuine partnerships require we have share profits or share risks. If no one is fully protected from loss, the true intention becomes leading, not partnership. In preventing manipulation in partnership contracts, fixing guaranteed return in mudharabah contract is its nature. Structuring musyarakah to shift all loss to one party violates the maxim. The maxim protects the spirit of cooperation and fairness. We promoting honesty and transparency. Islamic finance requires truthful disclosure and ethical conduct. An intention to deceive, hide defects, and exploit information asymmetry invalidates the contract. The maxim enforces trust, accountability, and good faith in transaction. Next, we correct classification of contract, which is contract must be ruled according to what they truly are, not what they are called. For example, a transaction labeled as hawala but intended as kafala must be treated legally as a guarantee. This avoids misallocation of rights and liabilities. Next, we have a strengthening Sharia governance. Sharia boards must be assessed in product design, contract execution, actual market practice. Compliance is not achieved through document alone, but through consistent Sharia aligned behavior. Next, in alignment with Maqasid al-Sharia, the maxim ensure financial transactions serve higher objectives: injustice, fairness, prevention of exploitation, real economic activity. Islamic finance becomes a value-based system, not merely a technical alternative. Next, we have a relevance in modern Islamic finance market competition, increased pressure to mimic conventional finance. The maxim acts as a moral and legal safeguard against deviation. It preserves the identity and credibility of Islamic finance globally. The last one, we concluding point, which is al-umur bimaqasid ensure Islamic finance is in ethically grounded, economically meaningful, and Sharia authentic. Without sincere intention, Islamic finance risks losing its morals foundation. And that's all from me. Thank you.
My name is Muhammad Alif Brahma Rongzi. I will explain about the implication of maxim. Certainty is not overcome by doubt in financial transaction. First, the core function. They act as a critical financial stabilizer. Established states are not disrupted by mere conjecture or suspicion. Next, for the protection of status quo, is enforce the presumption of continuity. Is the ownership, debt, and the right remain valid until there is certain evidence to the contrary. Is the impact to prevent the frivolous disputes. The burden of the proof lies strictly with the claimant. Next, for the respect for precedents, it applies to the sub-principle let the actions rest on its edge. For the contractual stability, it validly conclude a contract create a state of certainty that cannot be dissolved by subsequent doubts, such as regarding the intentions. The objective is to uphold Maqasid Sharia, perception of wealth, by grounding the economy in empirical justice and hard evidence rather than the speculation.
Assalamualaikum and hi, my name is Awang Kumar Arif bin Awang Abdul Qadir. So today I will continue for the presentation for my subtopic, that is implication of the legal maxim. Harm is to be eliminated in financial transaction. So in this slide, I put 6 main key points for the subtopics. So the financial transaction must not cause unfair loss or exploitation, and no party should benefit at the expense of another. Harm cannot be removed by causing harm, meaning problem must be resolved in a just and ethical manner without oppressing other parties. This principle prevents harm before it occurs by ensuring fairness, transparency, and justice in contract. It supports consumer protection and regulatory intervention against harmful practices, and aligns with Maqasid al-Sharia by promoting welfare, justice, and ethical financial behavior. That's all from me. Thank you.
Hi, Assalamualaikum warahmatullahi ta'ala wabarakatuh. So today we are going to exploring about the implication of maxim custom is a basis of judgment or al-adatu muhakkamatun. This principle is essentially the bridge between traditional law and modern business. It allows us to take common commercial practices and make them part of the Islamic legal rulings. The only major rule is that these customs cannot contradict core Sharia principles like the ban on interest. This ensures that Islamic finance is not stuck in the past but still relevant and stable in today's world. The first big implication is flexibility in financial transaction. Because business changes so fast, this maxim allows Islamic law to recognize and endorse new commercial standards as long as they do not involve in riba or interest. For example, trade customs are not same everywhere. Pricing and contract structure might be changed depending on the region. By respecting these local customs, banks can create products that actually fit the needs of the local people. A classic example is how food grain used to be measured by volume, but today everyone weighs it. Because of this maxim, Islamic law accepts weight as a standard for calculation today. It's also helped when contract is vague. If a price or currency is not specified, we look at the customary rate to fill in the blanks. The second implication is legal certainty and dispute resolution. Even though customs are usually unwritten, this maxim gives them legal teeth. It allows courts and arbitrators to use these practices as a source of law to solve disagreement. However, we do not just use any random habit. A custom must be universal and must have existed before the transaction started. When a contract has confusing words about things like delivery time or quality, the court looks at the market reality to find a fair answer. This prevents arbitrary decision and makes the whole legal processes much faster and more efficient for everyone involved. Third, let's talk about the improving of social and economic justice. The goals of Sharia is fairness, and this maxim is a tool to achieve that. For instance, if an agent is told to sell something but the price isn't set, the maxim forces them to use the reasonable and customary price. This protects the owner from being cheated. Think of the maxim as a moral filter. Just because a custom is popular doesn't mean it's allowed. If a custom is common but causes harm, like a practice of charging interest, is completely rejected. This ensures that business is not just about following the rules, but about doing what is ethically right. Last but not least is the maxim balanced with tradition and modernity. It allows a legal system developed centuries ago to stay competitive in today's high-tech global financial market. Because of these principles, scholars can approve modern tools like digital payment system and electronic trading platform as long as they stay within ethical boundaries. This allows for regulated development. We can use the most modern financial tools available to achieve the holy goals of Islamic law. This is why Islamic banking is seen as a viable, moral, and modern system today, rather than just a replica of the past.
Assalamualaikum warahmatullahi wabarakatuh, and hi, my name is Jumasna binti Kahar, and I will continue for this presentation, which is the implication of the maxim, hardship biggest facilities. First of all, an important implication of this maxim is that it allows for Sharia flexibility when strict regulation cause genuine hardship. Based on the case study, the Sharia maxim is used to ensure that Islamic law remains practical and responsive to real-life situation. In Islamic finance, this means that regulation should not be applied in a way that creates excessive burden when people face unavoidable financial hardship. Secondly, this method implies that Islamic finance aims to protect the maqasid al-Sharia, especially justice and social welfare. This case study emphasizes that Sharia methods are closely related to the objective of Sharia. Therefore, financial decisions should focus on eliminating harm and preventing oppression, rather than simply fulfilling the form of a contract. Then, moving on the third implication, this method allows for practical financial solution in Islamic finance. Islamic financial institutions can offer solutions such as payment rescheduling, debt restructuring, or temporary moratorium when customers face real hardship. These measures are permissible as long as they do not involve injury or unjust enrichment. After that, another important implication is that this method support the adaptation of Islamic financial product to the modern financial context. Due to the complexity of today's economic system, Sharia scholars rely on this principle to adapt contract and structure so that Islamic finance can remain competitive while still adhering to Sharia principles. And finally, this method also implies the need for strong Sharia governance. The flexibility provided must be used carefully to prevent abuse, over substandard practices, or imitation of conventional finance. So, overall, the difficult giving is method plays an important role in Islamic finance by ensuring flexibility, protecting Sharia objective, allowing for practical solution, and supporting adaptation to modern financial challenges while maintaining the integrity of Sharia.